My name's Anton Georgiou. I read over the petition that was filed, and the wording of that petition actually uses the word detriment. It says that that it would be detrimental to the children not to have visitation with the grandparents. But I don't think that they actually need to go that far. I don't think they need to show detriment in order to get what they want. I think that as long as the grandparents can show that there was a pre-existing close bond and relationship between them and the children in this case, and that father may not be, in a position to make a strong objection to this, that based on the best interest of these children, it would make sense to grant visitation. So when you're talking about the dad's rights, he does have a pretty strong right to exercise his authority as a parent. And that has been found to be a fundamental right under the Constitution, that parents can raise their kids as they see fit. But when you're talking about a situation like this, the court has to balance the father's right to be a parent and to exercise his authority as a parent against the right of these children to have continual contact and bond with their extended family and especially grandparents if they've been close to them. And so I would expect that the court would grant their petition given these circumstances. That is what the court primarily looks at, is the best interest of the children. And so I'm fairly confident that as long as the court finds that there's been a pre-existing relationship between these grandparents, given the fact that mom, in all likelihood, may be deceased at this point, is certainly out of the picture, regardless of what happened to her, there's going to be a good reason to join these grandparents. And you got to think, these kids must be really hurting to not have their mom in their lives, to not know what happened to their mom. And so to have that contact and to be able to see the grandparents is going to be really helpful. And I think that that's why the attorney that's representing the grandparents is using the word detriment, because in a real sense, it may actually be really detrimental to these children to not be seeing grandparents when their mom is gone and when they don't know where she might be or if they'll ever see her again. There's no need to throw dirt on dad in order to get what they want. But also, even if he's a potential suspect, and certainly any time where you have these kind of facts where, mom may have gone out and sought the advice of an attorney, potentially filing for divorce, and then immediately after that, she disappears. I mean, given those facts, it's a given that husband is going to be suspect number one for the police. But being a suspect is not the same thing as being guilty. He's certainly not charged with a crime at this point. And so the court can't rely on that possibility. The mere fact that he might have had something to do with her disappearance isn't by itself a basis for the grandparents getting their request granted. Now, should it turn out that he actually did something, that he either knew about her passing and covered it up somehow, or that he was directly responsible for her death, in that case, there's no doubt in my mind that these grandparents would end up with full physical custody of these children at that point. The issue that these grandparents are dealing with is the mother may have gone to a divorce attorney. Maybe she even had some sort of established date of separation where she told husband that the marriage was over and that she didn't want to be married to him anymore, but she didn't file. And without a filed case, there's nothing to join into. So the grandparents are in a position where they're actually having to initiate a case. and the language of Family Code 3100 is permissive. There's a difference between shall and the word may. So when statutory language contains the word shall, that is a direction that the court needs to do something. It actually kind of doesn't have the option. When the language says may, what the statutory language is saying is that the individual judge in that case has the ability to make a judgment call about what he or she wants to do in that particular situation. So in this case, I would imagine that based on all the circumstances, the court is very likely to use its discretion to allow the joinder. And so, or not the joinder, but to allow the case to go forward to begin with. So once that occurs, once the court grants the grandparents permission to actually establish some sort of custody visitation orders, then the next part will be, what will those custody visitation orders be? And so oftentimes that then requires the court to set a family court services mediation date, where the grandparents and the dad would go and talk to a mediator about what kind of visitation schedule is appropriate. The other thing to kind of understand is that the visitation is usually very limited for grandparents. So although they can get visitation, that visitation is usually a few hours a month, maybe a phone call a week. You're not talking about equal rights equivalent to that of a true parent. So these grandparents can't ask for very much, and their petition reflects that. They're not asking for 50% time. They're just asking for contact. I think Dad is going to first attempt to just shut down this request to begin with. He's going to say that he does not want this visitation for whatever reason. You know, he doesn't get along with the grandparents, or he doesn't want the grandparents to bring up what happened to mom, and thinks that that's really the reason why they want to have visits with the kids. So he may bring up various reasons for why he's opposing the request, and the court will have to balance those arguments against what the court believes is in the best interest of these children. And I think the court will side with the grandparents. I can't imagine that the court wouldn't, given these facts. The court can say, you know, you should not discuss X, Y, and Z with these children when they're in your custody, and you should follow that. Now, the interesting question is, what happens if they don't, right? So first of all, there's an enforcement problem there, which is unless you have somebody listening in and standing guard and listening to everything that's communicated to these to the children by the grandparents, how would you ever know that they are asking questions? And so, you know, that's an unsolvable problem. You can order someone to do something, but if they don't do it in the privacy of their home, if they're violating that court order, how will you know that they violated it? And I think the only way that you will know is Dad is going to start probing the children when they come back to him. So he's going to start asking the children questions. What did you and grandparents talk about, right? And then if the kids say, "Oh, granddad asked about what happened to mom," now bingo, that might be a violation of the court order. But then that can put the kids into the middle of all this, because what the children might say to Dad about that is going to be hearsay. So at that point, it becomes a question of, is he going to try and file some sort of contempt? Is he going to try and call these children now as witnesses that trying to prove that they violated a court order? And the courts do not like that. They routinely prohibit children from testifying in family court because it's so much stress. And as you can imagine, in this situation, that would be, you know, doubly so. There is an argument to be made that to the extent that they are potential witnesses, the best thing to do is for the police or someone with an agency to interview the children and ask them what they heard and saw, and leave it at that, but not for grandparents to be trying to get them to recall things. And frankly, that can kind of taint the investigation to begin with. I mean, it does depend on the age of these children, but when you start getting people that are not professionals interviewing children and trying to get them to recall things, you can actually undermine the investigation. So I would never recommend that a client start interrogating the children, even if they think that the child might know something. If the child is a witness to a crime, the police should be able to interview them, but they need a really good reason. I think that they need to really believe that dad did it in order to overcome dad's objections. And I think that that's probably where they're hitting a wall and aren't able to do it, because they don't have anything on dad that's concrete. And if he's saying, no, I won't allow them to be interviewed, then they actually do need a court order from a judge that's saying, no, interview these kids. And that clearly hasn't happened.